Here representing the petitioner, Vernon Madison, who has been sitting on death row for the past several decades. I'm going to take 10 minutes and then reserve 5. Of killing people. Up until 1927, Alabama's preferred method of execution was hanging. Alabama imposes more death sentences per capita than any other state in the Union. 5 times more than Texas, another leader in killing criminal defendants. Up until 2017, and in fact in this specific case, Alabama allowed a judge to override a jury sentence. So if a jury decided that they felt as though the defendant should be given life without parole, Alabama let the judge say, no, we think he should get the death penalty. And the judge was allowed to impose death. In fact, just in this past year in Alabama, in February of 2018, a death row inmate, Doyle Ham, had a terminal disease and a long history of drug use. Experts told the Alabama Department of Corrections that they wouldn't be able to find a vein and they wouldn't be able to execute him. And Alabama said, we're doing it anyway. They left a death row inmate with more than a dozen puncture marks in his legs and groin and potentially penetrated his bladder. And in March of 2018, about 12 months ago, he's been on death row for decades. He suffered several serious strokes. After a major stroke in 2015, all he wanted, his mom had passed away decades earlier. He has slurred speech. He's legally blind. He's incontinent. He's unable to walk independently. And he has no memory of the offense for which he was sentenced to death. His vascular dementia, it's an objective diagnosis that appears on a brain scan. It's not made up. Reports from the prison are that he frequently urinates on himself because nobody will let him out to use the bathroom. And so again, in the 90s, was sentenced to death, not the jury. The judge decided that he should have the death penalty. The jury decided that he should have life without parole. His first 2 convictions were thrown out on appeal, one for racial discrimination in jury selection, and the second for prosecutorial misconduct. This is his 3rd trial. In 2017, Madison argued that he was incompetent to be executed based on these strokes that he had. The court found that he was competent, relying on their expert, Dr. Kirkland. After trial, it was revealed that Dr. Kirkland was addicted to drugs at the time. So the competency doc is now arrested. The 8th Amendment protects against cruel and unusual punishment. The court has not yet ruled that the death penalty in and of itself is unconstitutional. Have put limitations on states who wish to impose the death penalty on vulnerable inmates. As of the present day, you can't kill a juvenile. You can't do as a child when they can sexual act. And in 2007, in a Supreme Court case called Panetti, they revised their decision. And they said, it's not just insane, and that's an old word, but one they used back in 1986. They said they can't have if they don't have a rational relationship between their crime and their sentence, it offends us morally as a country to execute them. So now, In 2019, Alabama's requiring us to go back again. And they're saying, even though my client can't remember that he can use the toilet in his cell to go to the bathroom, he's not suffering from delusions. And because he's not suffering from delusions and he's not insane, as the court used it in Ford, he should be executed. Fair minds cannot question his incompetency based on the Panetti standard. He does not rationally understand the connection between the crime he committed and the punishment he is to receive. We all know this. The trial court held, in light of everything, that he's competent. He understands. He can't use the toilet in his cell, but he understands that there is a connection between the crime he committed and his execution such that it wouldn't offend us morally as a country. The trial court relied on Dr. Kirkland to find this holding of competence. The trial court was wrong. To execute Mr. Madison would be a moral offense to our country. Dostoevsky said, the degree of civilization in a society is revealed by entering its prisons. We shouldn't be a country who kills people, and we certainly shouldn't be a country who kills Vernon Madison. I reserve my last 5 minutes in rebuttal.
Thank you. Some other facts in this case. Vernon Madison, a career criminal with 3 prior felony convictions, including armed robbery, assault, shot his girlfriend, Miss Cheryl Ann Green. When an officer showed up, Julius Schulte arrived to help Mrs. Green. He ambushed him and shot him too. Mrs. Green later testified to these facts. Mr. Madison did not contest them or dispute them at the time. Mr. Madison then spent the next 30 years filing appeals after appeal, receiving 3 new trials, convictions in all 3 of them, including 3 death sentences, 2 by a jury and 1 by a judge. He is now disputing those sentences on the basis that during those lengthy appeal processes, he had succumbed to dementia, and as a byproduct suffers from a 58% mental recovery rate. So some days he knows where he is, some days he doesn't. Some days he is aware of the death sentence and what the death sentence means, others he doesn't. Due to this affliction, his lawyers now claim it would be cruel and unusual punishment to put him to death, even though he was aware of the actions he took when he took the life of Mr. Schulte and almost took the life of Mrs. Green. No one questions these facts. But more importantly, 79% of Alabamans support the death penalty. That means almost 4 out of 5. The claim that there is some sort of evolving standard of justice applied in these cases is a complete myth. I respectfully contend that the only things evolving are the values of the Ivy League elitists in Washington. The values of the people in the states haven't changed much on this issue over many years. The court is therefore undermining the will of the American public on a whole. It has chipped away at the ability of the people to employ the death sentence in penalties in cases like Roper v. Simmons, Atkins v. Virginia, Ford v. Wainwright, and Panetti v. Quarterman. If the court finds in favor of Mr. Madison in this case, it will create a lack of legal clarity, a principle of uncertainty that the court itself has stated it should avoid in other cases such as Miller v. California and the Virginia State Board of Pharmacy v. Virginia Consumers Council. The court itself has stated it wants to avoid the principle of uncertainty because in the future, whereas it applies to this case, lawyers will be able to utilize this precedent to thwart executions for criminals who simply claim they can't remember what they did. And more importantly, it doesn't allow states to apply these types of rulings in an unmoored standard. A finding in favor of the defendant will further institutionalize a legal shell game, a legal sleight of hand that is being played at the court. The flawed precedent of Panetti v. Quarterman in which the court stated that someone could not be put to death, that they could not comprehend the reason for their imminent execution, has created too much legal ambiguity and allows for the capricious interchangeability of terms such as mental disorder and psychological dysfunction, amongst others, without specifically applying a legal principle. For example, as with dementia, which is a mental disorder and a psychological dysfunction, someone with short-term memory losses can be executed. Someone without dementia but amnesia, which is a mental disorder and a psychological dysfunction, can't remember, can be executed because even though they don't remember the crime they committed, they understand the rational basis for their execution. But someone with dementia and a long-term memory loss, that person can't be executed because if we take Mrs. Karen Perry's argument, there's an underlying medical condition, a psychological dysfunction. Even if on some days, they can understand the rational basis for their execution. So I ask, so alcoholism and drug addiction are both mental disorders categorized under the DSM-5 as medical conditions. If one were to black out while high or drunk or both, which happens often, goes and takes a gun and shoots 10 people in a bar, then wakes up with no memory of that, is that person eligible to be executed? Yes, because he understands the reason for his execution, or no, because he has a long-term memory issue that's related to an underlying medical condition, a mental disorder that causes psychological dysfunction, like a blackout. The lack of legal clarity here violates the court's own precedent. I shouldn't give you my pen. In creating a legal principle of uncertainty. Here in this case, it creates too much legal ambiguity, and the court should avoid doing what it's doing. These are delicate political issues to be left to the state legislatures to handle. The great anti-federalist lawyer, Robert Yates, wrote in Brutus number 11, for his fears of the constitutional system that eventually be ratified by the states. He argued that due to the structures and the institutional power arrangements created by the proposed document in 1787, eventually all the vital decisions of the American life will be made by unelected jurists at the nation's capital. This, he argued, would be the essence of tyranny that the Constitution was ironically created to prevent. I strenuously argued that the people in the states should decide these delicate death penalty matters through legislation. If, for example, the state of South Carolina wants to execute that coward Dylan Ruff for slaughtering people in a church simply because he didn't like the color of their skin, that's okay with me, regardless of the state of his mind on his eventual execution date. If the state of New York wants to give Colin Ferguson life in prison for doing the same thing on the Long Island Railroad long ago, that is also okay with me. These delicate matters need to be left to the people, not to the broad strokes of unelected judges in Washington, who are making things worse by handing down arbitrary decisions without legal clarity and creating a principle of uncertainty in violation of their own precedent. Thank you very much. I think I reserved 5 minutes, right?
6.
Okay, so I'm just gonna clear up several inaccuracies. So my opponent argues that we need to have decisions made by the people in these cases. The people ruled that Madison should be sentenced to life without parole. We had an unaccountable judge override that decision. So in that case, he should be sentenced to life without parole, following my opponent's own logic. Second, my client says we should err on the side of execution, of killing somebody, because it would be messy and too difficult to figure out whether a doctor says that he doesn't have a rational understanding. We already make these decisions in our courts constantly when we decide whether or not a defendant is competent to stand trial, whether or not a defendant can sit in front of a judge. In Philadelphia, we have competency hearings all the time before trial. We make those calls. My opponent raises the issue of voluntary intoxication. We've held for so long that that's not a defense. Of course not. Of course it's not a defense that you were drunk or high and killed somebody. It might lessen the state of mind, but it's not a defense to a crime. That's settled. This is vascular dementia. It shows up on an MRI. You know, I think my opponent, based on his argument, would have us kill somebody who is in a coma and say, well, you know, he knew what happened at the time. At the time he killed somebody, he knew what he was doing. So even though he's in a coma now, let's wheel him into the gas chamber and execute him. Finally, my client argues that the people are for the death penalty. And while I agree in some instances they may be, and in Alabama they may be, I would say this. I would say that the people, he brought up Roper v. Simmons, the people aren't in favor of killing children. I can't think of anybody I know, and I think this might even extend to Alabama, that we don't want to execute children. You know, he brings up elitist Ivy League institutions, which is kind of coded language for the people want to kill children. I don't believe that. I think we're better than that in this country. I don't think that people want to kill children. And finally, he says it would be too difficult. We already make determinations of whether or not somebody knew the difference between right and wrong. You know, that's an incredibly difficult determination to make. And our courts do it all the time with experts. That's how we decide if somebody is not guilty by reason of insanity. Thank you.
I have a question. Could you clarify your client's state of mind when he committed these crimes?
Sure. There's no question that he was lucid when he committed the crime. He wouldn't be on death row unless he did something horrible.
And he's had no other instances of any, other than the three. But what I'm saying is before, when those instances occurred, there has been no findings that he's had any PTSD.
After several strokes, one of which resulted in vascular dementia, which is a medical condition that shows up on an MRI.
Okay.
What was the last psychological level?
He's continuing to decline. So it was in 2017, this has procedurally been going back and forth for the past 3 years, but as of oral arguments 3 months ago, the representation to the court was that he is continuing to decline.
When was the vascular dementia diagnosis?
2015. And it's severe dementia. It's not mild, it's not moderate, it's severe dementia.
Caused by the stroke.
Yes, caused by
And what was the first stroke?
he's had several. The most serious one that was picked up was 2015.
May I?
Yes.
First of all, counsel, thank you for both being here. It's a very important issue, a very sensitive issue. With that being said, as you can well see, I'm the senior member of this panel, at least in age. I'm approximately about to approach my 89th birthday, and maybe what I'm about to say might lend itself to the need for term limits or even Supreme Court justices. Ms. Canterbury.
Yes.
Your introduction was very interesting.
Yes.
I'm just not quite sure what it has to do with this case.
You don't think the history of Alabama and the motivation of their use of the death penalty informs our current case?
Well, what's happening is, because, and again, I'm 89, I can't seem to get past your intro. So I'm just wondering if you're here today to tug at my emotional heartstrings, or if you intend on making a constitutional argument for your client.
Are you going to say the same thing about my opponent?
I might.
I think I've heard several bad acts that probably shouldn't have been brought up that are there to tug on our emotions.
Other questions to you?
Right, you know, I think that that's fair. I think if we look at the clean legal issue, it should be ruled in my favor. He doesn't understand what's going on. And I think that the history tells us that we can't keep doing this in our country.
Thank you, Stan.
You're welcome. Justice Love. Yes.
Is there any precedent that takes into consideration the decline of someone's health after they've been incarcerated? Because he was clearly, aware of his crime as he was doing it, and now that he's been on death row for so long, his health has been, declining, so he may not be coherent now. But does that have anything to do with
It's
the
the
punishment of the crime?
It's the Panetti standard. So the Panetti court, my opponent said that you were misinformed when you made the decision, but it is the current decision. In Panetti, they said that regardless of what happened at trial and regardless of the defendant's mental state at trial at the time of execution, the defendant has to have a rational understanding and connection between the crime and the punishment. That's a Supreme Court precedent. It was established in the context of psychosis.
I'd like to point out that, like I said in my statement, I'll say in rebuttal within my 5 minutes. There's no actual clear-cut standard, and what happens is these cases keep getting into the Supreme Court because there is no clear-cut standard. The actual petitioner in this case, in their request for a writ, they actually confused the court and said they were going to argue on one basis, and then made another argument when they got to court, which is this dementia case, because it ties into an anti-terrorism and death penalty statute that they wanted to utilize during this case. But they actually didn't disclose that during the request for writ. So these cases are being arbitrarily decided on these terms that are being interchangeable. The use of insanity when we think dementia, or dementia when we insanity, and they end up getting in court to try to stonewall death penalties. And that's what basically this is going on. That's why I refer to a legal shell game. But I could use my 5 minutes at some point.
I would say that they don't get to court as a shell game. I would say there's a person involved who doesn't understand what's happening.
So now the same game that you talk about the shell game, you're using alcohol.
Well, yeah, using her principles, using that principle, you have to let those people off, even though that's a standard that she said. But using these new principles that she's applying in this case, that she wants to apply in this case, you have to let those people off because there's an underlying medical condition, which is alcoholism, and there's a dysfunction, a mental disorder associated with that, which is blackouts. If you use her principle, yeah, in this case there'll be dementia, but in the next case, even though that one will be that has been settled a while ago that you just don't remember, it is no longer going to be just decided. It's going to actually have to be applied in that case, and that's why I brought it up.
We're not looking at the time of the crime. We're looking at the time of execution. My opponent is disingenuously conflating those two things.
Ms. Canterbury and Mr. Roxas, I'm going to ask a question pretty much as a follow-up to Ms. Canterbury's her recent comment. I would like you both to answer it from your perspectives. So most of us, myself included, are hopefully going to get bold. And clearly, appeals in these types of cases, death penalty cases, go on for many years, even decades. Are you suggesting or not suggesting that a convicted defendant sentenced to death should be spared the penalty simply because he lived long enough to develop health issues?
No, we're not arguing that health issues make it so that you can't be executed.
That's what she's saying.
What you said.
I say that we should execute. They committed the crime on the date of the crime. They were coherent, they were not legally insane at the time of the commission of the crime, and they should be executed.
Should we execute somebody who's in a coma?
Absolutely.
Should we dig somebody up who's dead and burn their body?
Let me ask you this. We have this is getting off topic, so I'd like to avoid it, but the reality is, we put people to death all the time. We euthanize them basically by denying them a food source. People who've never committed a crime, they're laying in a bed simply because they're in a vegetative condition, and we deny them a food source, like Terry Schiavo years ago. So there's this incongruence with how we treat end-of-life issues, where we want to afford all this sympathy towards criminals who killed people, and we don't afford it to people who are actually laying in a bed who are good people for all these years. So I think there's an incongruence in the argument. Can I get to my 5 minutes? Okay. No, I didn't. I would like to point out, the people speak, not just through the acts of the government, but also through legislation, the legislature. So they have to create laws. Ms. Perry, she talks about anomalies, about these cases where, certain things have occurred, and certainly, people who missed veins, and I don't think that I'm defending that at all. I think the execution should be as efficient as possible. But she always forgets the victims in these cases. She brings up the children in Roper v. Simmons, or Thompson v. Oklahoma, the cases she brought up in passing. The one case, three kids, 17 years old, kidnapped an 84-year-old lady, drove her around in the trunk of her car all day, beating her, tossed her off a bridge, connected to a chair and a brick, fully alive at the moment. All right, these are the victims that she's complaining she's defending. I mean, I'm arguing here that if the certain states want to not allow the execution of those people, protect them, that's their decision, not the Supreme Court. Now, another argument I'd like to make is that there is this confusion that we have with these terms, and we keep mixing them up, and we allow for great clarity, a lack of clarity on the Supreme Court because we haven't a defined issue. One of the ways this got into the court is this mixture of claiming insanity versus using the term dementia. I mean, and because they use the word insanity in one application and the state didn't utilize the term dementia, that's how it ended up at the court. So that's what I'm talking about, the shell game, conflating mental disorder, conflating mental dysfunctions to actually push these things off. What they're trying to do is push the death sentence off, which is what is justice in these cases. And they're utilizing the massive amount of appeals in the courts to get this. This gentleman was afforded due process multiple times, and he was sentenced to death. Right? That's the laws on the books in Alabama. If New York's are different, that's fine with me. But I think the people in Alabama have spoken through their laws. And 80% of them, almost 80% of them, support the death penalty. And that's all I'm saying. All right? In this case, this gentleman deserves the justice he was given by the state of Alabama.
I just have a question for clarification purposes only. There were 3 trials.
Yes.
Okay, and 2 were mistrials.
Yeah.
The 3rd trial, was that a jury trial or a bench trial with regard to the sentence aspect?
Jury. Alabama until 2017 used something called judicial override, where the judge could impose death even though the people spoke. And the people said that this defendant should have life without parole. The Supreme Court has since questioned its constitutionality. And I will say one thing, we're talking about playing on emotions. Bringing up the victims, I think, is playing on emotions. And I just want to tell everybody in this room that Roper in the Supreme Court case was 14. He was 14 years old, to play on everybody's emotions. And my opponent is saying, let's kill him. Right, but in Roper, the Supreme Court case that ruled against the death penalty, he was 14, and my opponent wants to kill him.
But didn't Roper
Committed an adult crime.
Didn't Roper have to do with the fact that, yeah, it was an adult crime, but that they went to the fact that he was 14 at the time he committed the crime? That's not what we're dealing with in this case.
No.
Unless I'm missing something.
No, I mean, an adult who actually knew what he was doing, admitted what he was doing, has been through due process 3 times. And I'd like to also point out that to make the misconception is that she brought up Mr. Kirkland and said that they arrested the actual findings. Well, Mr. Goff, the doctor, actually retested him and found the same things that Mr. Kirkland found. And so you're deceiving the court.
Mr. Goff is the defense expert. He did not hold for competency. You're deceiving the court.
Is that the doctor who was ultimately arrested?
That's
No, that's
Kurt
Kurt.
Flynn. That was Alabama's doctor.
And the reason why he's refusing additional tests is because he doesn't want the test. Obviously, they're stonewalling to make this process seem longer. And that's what I'm talking about with regards to applying the law arbitrarily. They're allowing for these loopholes to push out as justice that was mitigated to him by the state of Alabama.
I would say we're applying inhumane laws in a way that's a little bit more
Be sure
humane.
honest.
Counsel,
Be
counsel.
sure honesty.
Counselors, this is our court. Correct me if I'm wrong, because I'm still stuck on Ms. Canterbury's intro. Aren't the issues you're arguing issues, the trial issues, and really that don't have anything to do with what we're doing here now?
It's
Right.
an Eighth Amendment issue.
It's an Eighth Amendment issue, but as I'm pointing out, there's the Eighth Amendment issue, how it's applied. And the Eighth Amendment doesn't not allow for the death penalty. In Greg v. Georgia, it allows for the death penalty. We've had numerous cases which allow for the death penalty.
And we've had numerous cases which don't allow for the death penalty. And bringing up death penalty case law in an intro is appropriate in a death penalty case. Respectfully, Your Honor.
But I'd also point out in Wainwright and Ford v. Wainwright and Panetti v. Quarterman that the court chipped away at the existing traditions in the states which allow them to make these decisions on their own. And this has steadily happened over the years where legal elites in Washington, in congruence with the will of the people in the states, have undermined the will of the people in those states through their decisions. She keeps calling the court we. Well, I don't think that reflects we. 9 Ivy Leaguers sitting on a court in Washington, we. I don't think that's we.
I would say this, I think that if you look at our history, the federal courts have done a really good job of stepping in and policing the states
Really? And
when the
Dred
states
Scott?
have deprived individuals of their constitutional rights.
I would argue that's not true, but that's a large argument.
Should we take questions from the audience? Oh, okay.
I think you guys answered this.
Yes.
When he was first arrested, they committed a psychological exam.
Yes, he did
And
not,
he denied, correct?
he did not have any cognitive dysfunction when he was
But he
arrested.
agreed to the psychological exam when he first committed these crimes, is that correct?
I don't even know that that's in the record.
No, it
Did
is.
he allege that he was insane at
Well,
trial?
no, they did because she had issues of paranoia. And even Mrs. Green testified that he was having issues of paranoia at the time, but the court found him legally sane and for trial, competent for trial.
Okay, thank you.
No problem.
I have a question.
Yeah.
So going back to Panetti, so what it looks like they said that criminal defendants sentenced to death may not be executed if they do not understand the reason for their imminent execution.
Correct,
And you said that he no longer knows, he remembers or recalls the crime.
correct.